Hello everyone, this is Nazarat Fatima and you're watching LiveLaw. Today in the video, I'll talk you through an important judgment passed by the Supreme Court yesterday, that is 30th of March. We know that granting bail in NDPS Act is a very difficult proposition since the bail is granted rarely because of the operation of special provisions in the Act for grant of bail. But the Supreme Court in the landmark judgment has stated that inordinate delay or long delay when a prisoner is under trial can also be a factor for consideration of grant of bail. The appeal was from a case in which the appellant was involved in the supply of ganja along with 4 of his co-accused who were carrying more than 100 kgs of a prohibited substance. One of the co-accused made a confessional statement and showed Muhammad Muslim, who is the appellant, to be involved in the case. It was also noted that the accused was arrested 7 years ago and was only 23 at the time of arrest. The appeal was filed because the accused was denied bail in the Delhi High Court and was heard by a bench of Justices Sri Ravindra Bhatt and Dipankar Datta. The bench, while granting bail, held, and I quote, "Grant of bail on ground of undue delay in trial cannot be said to be fettered by Section 37 of the Act, given the imperative of Section 436A, which is applicable to offences under the NDPS Act too. The court would look at the material in a broad manner and reasonably see whether the guilt of the accused may be proved. The judgments of this court have emphasized that the satisfaction which courts are expected to record, that is, that the accused may not be guilty, is only prima facie, based on a reasonable reading, which does not call for meticulous examination of the materials collected during investigation." The bench also referred to earlier judgments and said that the conditions mentioned under Section 37 have been upheld in many cases in order to strike a balance between the liberty of the accused and public interest. At the same time, the bench acknowledged that a plain and literal interpretation of the conditions under Section 37 requiring the court to be satisfied that the accused is not guilty and would not commit any offence would exclude grant of bail altogether, resulting in punitive detention and unsanctioned preventive detention as well. The bench held, and I quote, "Therefore, the only manner in which such special conditions as enacted under Section 37 can be considered within constitutional parameters is where the court is reasonably satisfied on a prima facie look at the material on record that the accused is not guilty. Any other interpretation would result in complete denial of the bail to a person accused of offences such as those enacted under Section 37 of the NDPS Act." The court held with respect to the trial and investigation and their connection with the stringent conditions for bail, and I quote, "When stringent provisions are enacted, curtailing the provisions of bail and restricting judicial discretion, it is on the basis that investigation and trials would be concluded swiftly." The decision in Union of India versus Najib was also referred by the bench because it was said in this case that stringent conditions under UAPA will not fetter the right of constitutional courts to grant bail on the ground of violation of fundamental rights. The judgment also referred to precedents which hold that right to speedy trial is a fundamental right. The statistical data regarding under-trial prisoners was also referred by the court, and it was said that 5,54,034 prisoners were lodged in jails against total capacity of 4,25,069 lakhs in the country. Out of these, 1,22,852 were convicts. The rest, 4,27,165, were under trials. The court also added, and I quote, "Laws which impose stringent conditions for grant of bail may be necessary in public interest, yet if trials are not concluded in time, the injustice wreaked on the individual is immeasurable. Jails are overcrowded and their living conditions, more often than not, appalling. The danger of unjust imprisonment is that inmates are at risk of prisonization." The bench finally concluded by saying that the courts have to be sensitive regarding such things and have to ensure that trials, especially in cases where special laws enact stringent provisions, are taken up and concluded speedily. That's all for today. If you like our content, please like and share. Also subscribe to LiveLaw and don't forget to press the bell icon for notifications. Thank you for watching.